Burglary in South Carolina. Burglary is the entry into a building or dwelling without consent and with the intent to commit a crime therein. It typically involves theft, but doesn't have to always mean that. The entry can be by force, such as breaking a window or kicking in a door, or it can be without force, such as entry by deception. Hi, my name's Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And today we're talking about burglary charges, and in particular, burglary third degree. For the prosecutor to show burglary in the third degree in South Carolina, they have to prove the following: that there was an entry into a building without consent and with the intent to commit a crime therein. It's a felony offense and carries up to 5 years in prison for a first-time conviction, and for a second conviction, it can carry up to 10 years. However, that sentence is at the discretion of the court. So let's talk about the elements of this charge and what they mean. What is a building under this statute? A building is any structure, such as a warehouse, an office, a store, that is a place where it's not a dwelling, where someone sleeps on a regular basis. It can also cover such structures as a vehicle, an aircraft, or watercraft. So as you can see, the statute's fairly broad in the type of structures and vehicles that it covers. So let's talk about entry. Does your body have to physically enter the building to qualify for burglary? No, it doesn't. Entry is defined as either the physical intrusion or the use of some sort of tool under your control used to enter that building. So that means even though you may never have physically entered that building with your body, if you use some type of tool to enter that building and take property from outside of it, that's not going to be a defense to a burglary charge. What about consent? What does that mean? If you are initially giving consent to lawfully enter a premises such as an office or a shop, and then you concealed yourself until that shop was closed, does that still mean that you have lawful consent to be in there? No, it doesn't. You can't get around the statute by concealing yourself once inside, because that person doesn't have knowledge that you're still in there. They're not giving you consent to stay inside that building once the premises are closed. That's not going to be a defense to this charge. So what are some of the defenses in these types of cases? Good lawyers know that it's important to conduct your own investigation and to really look at where the premises was and what it is when you're trying to defend some of these cases. What can often happen when you're dealing with juveniles, either they go into an abandoned warehouse or building, they go inside there and they start smashing windows and throwing rocks inside that building. Because that premises is abandoned, it doesn't qualify as a building under the statute. Now, it may be something else other than a felony burglary charge, such as trespassing, but that's a 0 to 30-day misdemeanor that does qualify for diversionary programs, which is certainly far better than having a felony conviction on your record. Another scenario that can happen from time to time is dealing with the intent to commit a crime therein. Wasn't that long ago when I was a prosecutor and I had a case where the person entered a building without consent, and it was caught on video, and there was an alarm that sounded that brought the police to the location. However, when we got that video evidence in, what we saw was that person was homeless, and they came in there and it was raining outside. They came in there and they did nothing more but fall asleep on the floor. There was no intent to commit burglary or commit a crime once they were inside that residence, and so it didn't qualify for burglary under the statute. Lastly, one of the common situations that happens is when a person takes stolen property to a pawn shop and then tries to pawn it. A number of times the owner will notify police, and then police will arrest that person and discover that that property has come from a residence or a building that was burglarized. However, without more, that doesn't meet the definition of burglary because they don't have any other facts to show that you were the one that gained unlawful entry into that building. Now, it may be something else, such as possession of stolen property, as long as you can show that that person had knowledge or should have had knowledge that that property was stolen, but it doesn't meet the level of burglary third in this state. So, if you have a burglary third charge and would like to discuss your options and any possible defenses, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.